for the past 60 or 70 years. The whole approach toward agencies, particularly scientific agencies that are charged with the power of protecting population health, CDC, EPA, Interior, organizations like this, agencies like this, have been understood as having very broad powers. Congress would write legislation to give them a broad grant of authority and let them then bring the best science to decision making, with a lot of deference from the courts, at least where the agencies had gone through a reasoned rulemaking process. All of a sudden now the court has reversed course and basically has said that unless agencies have very, very specific, problem-specific directives from Congress to step in and address a problem, it will consider their actions outside the bounds of what would be legal. And the problem with that, particularly for the scientific agencies, is that the reason Congress sets up a broad grant of authority is precisely because lawmakers can't predict in 1970 what the problems are going to be in 2023. If an agency has to go back each time to Congress to sort of ask a mother may I with very, very specific instructions, that means that the agencies cannot respond to emerging critical problems as they occur. Congress is very slow and has no experience drafting particular legislation. So it's essentially a deregulation activity meant to freeze agencies as opposed to empower Congress. Only last week, the court heard arguments on the affirmative action policies that have been in place for 50 years now, and will decide probably during this term whether or not to allow universities, and by definition, therefore, a lot of other private and public sector entities, to be conscious about race as one of the many, many factors they use in selecting candidates. And this could be a very serious problem, obviously, for diversity at universities. That's a case that everybody's watching in public health, especially because of the implications for the health professions, which have health profession schools have put such emphasis on a diverse workforce that this could really harm things. A second case, which is going to be argued tomorrow, involves whether or not Medicaid beneficiaries, so there are 88 million Medicaid beneficiaries now, Medicaid beneficiaries can protect their rights in court when state officials act in ways to curtail their rights. So for example, a state deciding totally unlawfully to suspend enrollment, to not take any new applications, or to cut entire benefits out of the program that are required benefits. These are rights in Medicaid: the right to apply, the right to coverage if you're found eligible, the right to certain benefits. And one of the things that's kept Medicaid the strong program that it is that beneficiaries, like other insured people, have had a right to go to court if somebody threatens those rights, which means that state officials, have towed the line on the law. The court is poised now to take the right of access to the courts away, leaving almost 90 million people with no way to enforce their insurance protections. It also would ultimately and completely change programs like SNAP, child welfare, other big federal programs that are administered by states.